Hello and welcome back to another video on this channel. We have another test today for Midpage. So this is part two. The first part, maybe it was a fluke. Maybe it was a total coincidence that it impressed me. I thought it did a good job. It could have done a little bit better if it had identified a few more of those cases, but it brought us to the most important one, which I think is huge. And it leaves the comments within it that are going off of what you've already showed interest in, and it takes us right to the circuit split within it. So, anyway, in my opinion, it did a great job. All right, now we are going to be trying a new problem. This one is in a totally different area, and admittedly, this is not Midpage's strength. Okay, Midpage's strength is established areas of law, not these cutting-edge legal questions. But we're doing it anyway. And they did a good job last time, so we're going to see if they can do a good job this time. All right, so let me go ahead and share my screen. And I've already got this set up, so this is going to be a much shorter video than the last one was. Yeah, so you can see my screen. All right, so here we are going to be testing the legal question of, state ban on biological male participation on biological female sports teams. So yeah, we've entered in a set of fake facts. Plaintiff is a 14-year-old male to female transgender girl who's on hormone replacement therapy and puberty blockers and plays a non-contact sport. They are a runner and a swimmer. Let's go ahead and, oh, and here's the other cool thing. So those are our facts. And we said the motion, we're seeking its preliminary injunction. We want it to be granted. Okay. And then we're going to include our question, whether a state law that bans transgender girls or biological males from participating on female sports teams in public schools, but does not ban females from participating on male sports teams is a violation of the Equal Protection Clause of the 14th Amendment. What is the circuit split? All right. We're going to throw that in, show our interest in the circuit split, but that is kind of like it'll flag it if if the cases talk about it. Otherwise, it doesn't really do too much with it. And that being said, let's include your facts to guide the search. Why not? We are doing a review, aren't we? And I like that it suggests a Boolean search. So like, guys, you don't like what you get, you can copy and paste this into Westlaw. But assuming you have this, you don't have Westlaw. I really think this company is going to get bought out in the next couple of years by Westlaw or Lexis. But then they'll just do nothing with the innovations of this clipboard style thing. All right, and I think yeah, so it's because I've asked it to use the facts, it's going to automatically do the compare facts feature, and it's automatically going to do the favorability. I like that. And right off the rip, guys, BPJ, you have to talk about this case if you're going to look at this issue. Hecox, you got to talk about this case. Uh, Gloucester should be coming up. Okay, so we don't have Gloucester. So that's a little bit of a missed opportunity, but maybe it's on page two. Man, I mean, this thing is working. It's amazing what it's doing. Clark versus Arizona. That's a good case about a boy trying to play on a girls' volleyball team. Um, and they said, no, get out of here. All right, we're going to go back to page one. And let's see sort of what it does to the good cases, how it tabs them up. So let's start off with BPJ. This is a case that's bad for us. So this is so cool. Both of these cases involve transgender girls seeking inclusion in sports teams that align with their gender identity. Already, this is using the language of the argument you would make. That's what matters, right? You're arguing as plaintiff that it's about gender identity, not about biological sex. BPJ is 11, is similarly seeking to play on girls' sports teams. Dude, if I'm making an argument and I've got just these facts are so easy to pull, is also, okay, well, your client is a runner and a swimmer, not really relevant. Transgender girl has taken medical steps to align their physical characteristics with their gender identity. BPJ has taken puberty blockers, just as your client is undergoing hormone replacement therapy. The goal in each case is to attain a preliminary injunction. Cool. Revolves around the law defining sports teams by biological sex. Okay. And you want it granted, this is not favorable. Cool. Both situations undergoing HRT, seeking to participate, gender identity, belief, favorable. All right, I, I'm. I think this is a really cool tool. Affirming the court's preliminary injunction, blocking the enforcement. Oh man. All right, so let's go ahead. Can I open this in a new tab? And then we'll go ahead and look at this one. See how they do with the new tab. Oh yeah. All right, let's let it generate some comments. Um, BPJ. Yeah, the Gloucester County, I guess it's not that bad that I think the Adams case is another one that could have come up. Adams by and through Casper. I don't think we saw that one in our search results. Would have been cool. But that might have been getting towards I think those were both more Title IX oriented than equal protection clause. So we really shouldn't hold it against them for not bringing it up. We are asking about equal protection. All right, let's find these 5 comments. Court finds WVSSAC is a state actor due to public. And okay, what's the next comment? Intermediate scrutiny applied to law separating students by ethnic assessment. Yes, you do absolutely. Intermediate scrutiny, Con Law 101. I wonder if they cite the Virginia case. Let's just ask it. Or is it going to be like right up there? HP Row, Sessions, University. Okay, we'll ask it in a second. BPJ's argument, exclusion due to biological sex ignores hormone therapy impact on athletic advantage. Okay. Court affirms legislature's definition of biological sex is substantially related to providing equal protection, equal athletic opportunities for females. Okay. Complies with Title IX based on biological sex, doesn't violate the law. All right. Let's see what the comments are for this one. Categorically bans transgender girls. And it subjects only female athletes to invasive verification processes. 14th Amendment, Equal Protection Clause, state can't discriminate against classes arbitrarily or to harm unpopular groups. Did they cite Lopez? Okay. Heightened scrutiny applies. Oh, a little heightened scrutiny. Are they using a higher standard than intermediate? Because it's not strict, they're saying heightened. Didn't learn that one in con law. We have rational, intermediate, and strict. What is heightened? Do not err, including. Okay. Clark, this is the volleyball case we talked about. Sex verification process deemed invasive and discriminatory against female athletes. Court found no substantial relation, interesting, between the categorical ban on the act, ban and the act's objectives, such as women's equality. All right, guys. There you have it. Midpage is 2 for 2. It's not supposed to be good at, you know, cutting edge legal questions, yet I think this is a great tool. And I would encourage all professors to allow their law students to use this. Good job, Midpage. And I'll go ahead and end the video there before I just continue to ramble. Again, like these tools are really cool here, and you can um, ask it for more columns about things you're curious about, and I really think this is next level. So, all right, end the video there.